Catherine? We can't hear you.
I'm muted, everyone. I got everyone started on WebEx and then muted myself. All right. Hi, everyone.
Hi.
Welcome to the ARC National Center on Criminal Justice and Disability webinar. My name is Catherine Walker, and before we begin our presentation, I'd like to cover a few basics, especially for those of you new to WebEx. Participants are in listen-only mode. If you need help during the presentation, you can post questions in the chat box on the side of your screen or in the Q&A section. We'll be happy to help you. At the end of the session, there will be a time for questions. You can either post those questions in the Q&A section or in the chat box. If you don't want your name shared with your question, please type private before your question. You can also email questions to ncccjdinfo@thearc.org. If we don't get to your question during the presentation, we'll follow up with you afterward. This webinar is being recorded and will be posted on our website. We'll send you an email letting you know when it's available. We have one final request. You will receive a session evaluation after the webinar. Please take 5 minutes to complete it and send it to us. This webinar is funded by the United States Department of Justice, Bureau of Justice Assistance. Thank you for your participation today. Please welcome Program Manager of the ARC Justice Initiatives, Leanne Davis, for some opening remarks.
Good afternoon, and Catherine, I'm glad you decided to unmute yourself. You have done a wonderful job on all of these webinars, and I just want to thank everyone for being on the webinar today. I know some of you may be new to us, but many of you have been joining us throughout our 2 years with the National Center as we've really worked hard to provide some important content around issues that are affecting people with intellectual and developmental disabilities in the criminal justice system. So today we're excited. This is our third webinar/white paper release that we're doing two things together to really delve into these issues that we feel that we've seen across the country. We've heard from many of you as well. But these are issues that we really don't have easy answers to. And so that's why we're excited to bring the area of juvenile justice in a laser sharp focus today. And I want to acknowledge our wonderful presenters that we've got who also authored the white paper that you will have access to today as well, starting with Karen. And I know that you will have their bios will be given to you as they present, but I just wanted to acknowledge Karen, Gretchen, Lee, and Catherine because they've been working very hard with us on many different projects, and their passion and their dedication to this issue is so clear. And what they've done, some folks I've worked with for a number of years within juvenile justice issues. And I'm just very excited to have everyone here together in one place at one time to really talk about what works, what doesn't, and where we need to go in the future. And as we listen to our participants today, I wanted to bring up some discussion points as well. This is really an opportunity for us to not only hear what the speakers have to say, but also be thinking about how does this apply where we live. So one of the first things I'd like you to think about is how do we prevent youth with intellectual developmental disabilities to become involved in the juvenile justice system in the first place? How are you able to do that where you're at? What are some strategies that you've used? And then hopefully you'll pick up some tips today from our speaker. And then how to effectively identify disabilities. We know that this is a really difficult thing to do. Much of the folks that we're serving, people with intellectual developmental disabilities, whether young or old, they can be seen as hidden disabilities. It's hard to identify. There's not necessarily physical attributes. And many times it takes talking to someone to understand that there's even a disability present. So that's one of the things to keep in mind. And then when the disability is identified, what next? Throughout the course of the pilot trainings that NCCJD has been doing, we've been training law enforcement, attorneys, and victim advocates. And one of the things that we run up against time and again is that even when we discover disability is present, you know, what services are available. And you'll hear that from Karen as she talks about Justin's story in a minute as well. So in your community, in your agency, maybe it's statewide, maybe you run a statewide program. What are the supports that are currently available for juveniles with intellectual disability, and be thinking about what is missing. And one of the things that we use within NCCJD and within our Pathways to Justice training is this model. Basically, it provides an overview of the criminal justice system. And I think it's helpful for us to look at this in order to start thinking about where are the gaps in services for juveniles with disabilities. Starting from first contact through investigation, jail, trial, plea agreement, transition, and then back to the community. We can take each case scenario that perhaps cases you worked on, and through our information and referral line, we get quite a number of calls where we try to provide supports as well. And this has been a useful tool for us to look at whether it's a community or it's an individual level. What is it that's missing? Who are the people we need to be contacting? Say, for example, if it's in first contact, is that the place where we need to focus our resources and energy to really start addressing this issue in a systematic way? So I'd like you to think about this model as well as you hear from the presenters today, and just sort of mull over what everyone has to say, because we have a broad range of topics here. Just as an overview, we're going to start off with Justin's story to really give a face to this issue. I don't think we get enough input around seeing people actually live these experiences. And I'm very excited that Karen's here to talk more about the documentary that she is close to finalizing, and that is so powerful in really bringing this issue, giving this issue a human face and showing just how critical it is that we provide supports and services in this way. And then we'll look at a brief history of how we got here, looking a little bit about juvenile justice issues in the past and where we are today. And then prevention, just strategies that advocates and parents can use to help prevent people with, or youth with intellectual disabilities from getting into the system, and touching on school to prison pipeline issues, as well as special education within juvenile detention centers. So we've got a packed program. I just wanted to give you a little bit overview of what we'll be talking about. And just again, thank you so much for joining us today. This is really an important issue, and we look forward to getting your questions and also hearing from you any resources or strategies that you have as well. So I will now turn it over back to Catherine to introduce Karen.
Thanks, Leanne. Karen Grout has over 25 years of broadcast experience and is a founder, president, and executive producer at Calamari Productions. In 1998, Karen made history by becoming the first television director and producer to gain state Supreme Court access, allowing cameras inside child welfare juvenile courts. Her work in the juvenile justice system led her to Justin, who she will speak about today.
Hi, everyone.
Hello.
Thanks, Catherine and Leanne, for the opportunity to be on this webinar today. I've had the great pleasure of learning more about the ARC and everything that the ARC does in relationship to juvenile justice issues for about the past year. And I have to say, when I look back at the history of how I became involved in covering a child like Justin, who is in the juvenile justice system and has intellectual and developmental disabilities, I can tell you that I was so naive as to the issues involved, and it's been through our work with the ARC that the ARC and folks like all of you have helped educate me on the subject matter, which then in turn allows us as journalists to help educate the public. So we're not only honored to work with the ARC, but we're very honored to prepare to release our new film, which is called Children of the Dumping Ground. Leanne and a couple of people at the ARC have seen some of the first cuts of the film, but I'd like to talk a little bit about how Justin came to our attention in the first place and what our experience has been to date on this subject matter. I will tell you that I've been filming inside juvenile detention centers and juvenile courts and juvenile prisons for the past 17 years, but I knew little to nothing about children with intellectual and developmental disabilities before this particular project. It was about 6 years ago that I was in one of America's largest juvenile prisons, a prison called Pendleton Juvenile Correctional Facility, which is just outside of Indianapolis. And the superintendent at the prison at the time was telling me about a specific unit at that prison that they called the mental health unit. So I was very interested to learn more about this particular prison unit. Now you have to understand, this prison is like any adult prison you would see. It's surrounded by razor wire, there are segregation units, there are cell units. So even though it only houses kids, and we're talking kids ages 10 to 21, it is a prison, and it's a maximum security juvenile prison. So I was interested to learn that there was a mental health unit. When I went in the mental health unit, I can tell you that there were probably 20-some kids in that particular unit at the time, and it was readily apparent to me that many of these children were low functioning. And at that point, I was struggling with the term mental health. And I think one of the things that has materialized for me as I've covered this story with Justin is so many people generalize the term mental health. And what I'm realizing is that in the juvenile justice system, people are lumping children with intellectual and developmental disabilities into the mental health category. And as I'm sure all of you know, because you are experts in this arena, there's a difference. And I think being able to make the distinction and bring to audiences literally around the world the difference between the two is one of the important things we can do with this film. I met Justin in that quote-unquote mental health unit that day, and I instantly realized that this was a little boy who had significant disabilities, and for the life of me, I could not understand how he ended up in a juvenile prison in the first place. It didn't take long before I asked a lot of questions about his particular case. They told me that Justin had a very low IQ, that he couldn't read and couldn't write. He was very low functioning. And so from there, I just tried to peel back the layers and find out what juvenile court sentenced him to this prison in the first place, and weren't there other resources in the community available for children like this, excuse me, who come through our courts. And that's when I discovered that in Justin's case, he had very little family support, none, quite frankly. He had no attorney, he had no guardian, yet he went through the juvenile courts, and a judge had the ability to say, we really don't have a place to put you, and so he simply sentenced him to the Department of Correction for what's called an indeterminate sentence. Kids who end up in the Indiana juvenile system with indeterminate sentences means they will stay in juvenile prison until they complete the prison programming. And that's everything from counseling and anger management. There's a host of things that they have to complete before they can be released. Well, for children like Justin, who are low functioning and have severe disabilities, completing those programs is impossible. So what ended up happening was, in effect, Justin became a prison orphan. And because he had no family who were willing to take him back in when he was ready to be released from prison, simply because the prison said, we refuse to keep him any longer. He is deteriorating. He is actually getting worse here. And since he can't complete the programs, we need to find a better solution for him and other kids like him. There was literally nowhere for him to go. So it was an odyssey, to say the least, in filming his story. We tracked Justin over a 6-year period of time for this documentary. I won't give away everything that happened in the film, but I think more than anything, what it does is illuminate the idea that we have probably tens of thousands of kids just like Justin in our juvenile justice systems all over the country. And the question is, who's looking out for these children? How many of them are there behind bars? What are the resources that are available in communities? that can be identified before these kids end up behind bars, because as every prison official in America will tell you, they are not equipped to deal with this population of youth. They don't have the staff doesn't have the training to deal with children with intellectual and developmental disabilities. Staff in juvenile prisons are there primarily for the, protection and safety of the kids who are there and members of the community, so that when they're released, they don't reoffend. And that's a different set of skills than what are needed for staff who work with children with disabilities. So our hope is that by releasing this film, people will see a face, Justin's face, and when you put a face to these issues, I think it helps bring home to the public what we need to do as a society to make sure that this doesn't continue to happen to other children, and to help find solutions not only for children who are currently ensnared in these systems, but for children who present with these problems who haven't been enmeshed in the juvenile justice system yet, but who might find a touch point with the system in the future, and to make sure that we're diverting them away from these punitive settings where they only get worse, and where, as far as we're concerned, from what we've recognized over the past 6 years, is really just a wrenching situation, not only for the kids involved, but for our communities in general. We just can't allow this to keep happening to the IDD community. These kids and families deserve better than that.
Hey, Karen, this is Leanne.
Yeah, Leanne.
And I was wondering if you just want to go through some of these pictures, just telling us a little bit about each picture.
Sure.
Here. Thanks. Do you see the one up on the screen now?
Actually, I don't. If you want to tell me which one it is, I can speak about it.
I think it's the one he's wearing a hat.
Oh, okay. So a special hat, I might add. If everyone else can see this picture, I'm not sure why I can't right now. Justin eventually ended up in a placement facility outside of Indianapolis that specifically deals with children with developmental disabilities. They did an amazing job with Justin while he was there, and he was placed there for a few years. That facility, called Daymar, actually has a wonderful prom every year, just like we all had when we were in high school. It's attended by all the kids at Daymar, and Justin last year was up for prom king, and we are happy to report that he actually won Daymar's prom king that year. So this is a picture of Justin wearing his prom king hat. He was thrilled when it was announced. This whole scene is actually in the documentary, so I think that it helps add a little levity to what can be a difficult film to watch at times, but it also shows what great outcomes can happen when everyone steps up and works with these children so they can have the same experiences that all kids want to have, regardless of whether or not they have disabilities.
And the next one is you with Justin. I believe it's his 18th birthday?
Yes, yes. We started filming with Justin when he was just 14 years old. And usually as journalists, we like to say, and you're trained to keep an arm's length from your subjects so you don't become too involved, so you can be objective in your reporting. But I will say, when it comes to kids like Justin, sometimes that's just a little difficult to do on a personal level. So I, over the past 6 years, have been a pseudo mentor for Justin. And so we make sure that every year when he celebrates a birthday that we're there with birthday cake and candles and gifts and celebrate just the way any family member would celebrate with their children. So this is a picture of Justin the day that he turned 18 and the birthday party at Daymar.
And then the last one was with the judge. You want to talk about how you worked with the judge in his case?
Sure. This is a picture of Judge Mary Beth Bonaventura. I still call her judge, although she is now the head of Indiana's Department of Child Services. She was a juvenile judge for 20-some years. We filmed in her courtroom for several years for a few other documentaries that we did. She is now the head of Indiana's Department of Child Services, and I think the good thing about that is because she had so many years experience on the juvenile bench, she brings a different perspective as the director of Indiana's Department of Child Services because she came into contact with so many of these children over the years when she was a judge. She was distraught when she saw the film and saw that one of her former colleagues had sentenced Justin to juvenile prison. In her mind, as in the minds of many judges that we've talked to since producing this film, I can't find another judge who says that they would have ever found prison an option for Justin, that they would have diverted him to one of the other systems, that they would have kept him in the child welfare system where there could have been more supports and less punitive action taken. So Judge Bonaventura has taken special interest in Justin's case, and she, like many of us involved in his case, has kept in contact with him and really kept track of his case to make sure that the best outcomes possible happen for Justin and kids like him.
Well, thank you so much, Karen. I cannot tell you enough how much we appreciate you being on the webinar, and we want to help you get the word out about children of the dumping grounds as much as possible to really, as you say, put a face to this issue. Just thank you for the wonderful passion you bring to this topic, and I'm sure there'll be questions for you later, so hang around.
Great, thanks.
All right, thank you again, Karen. Our next presenter today is Lee Mahoney. Ms. Mahoney has over 24 years of experience in educating students marginalized by disability and disadvantage, guided by the passionate belief that access to quality education is the pivotal solution to the majority of societal issues. Lee has served students both as a teacher and administrator in the juvenile justice and child welfare systems and in high-need urban communities. She currently works with the Robert F. Kennedy Children's Action Corps as its Director of National Education and Program Development, a role which allows her to advocate for policy and programming that supports all students. She brings with her extensive experience working with and designing programs for students with disabilities in the public system, those served in the community, and those in institutional settings. So with that, I'd like to welcome Lee Mahoney.
Thank you, Catherine. Thank you for everyone who's joined us today. This is a topic that's near and dear to my heart. I'll be taking you through an extremely brief overview of the juvenile justice system and some of the challenges it presents for youth with intellectual and developmental disabilities, both systemically and on a kid-by-kid basis. The first point is probably that the term juvenile justice system is something of a misnomer. It is not a tightly organized system. It's a loosely connected set of institutions and practices. So it could include juvenile courts, probation, law enforcement, juvenile treatment and corrections, community programming, and lots more depending on where you live. So these institutions are further stratified by state, county, municipality, maybe tribal organization, and they're all impacted by the specific ecology of their community, whether there's a lot of unemployment or a booming economy, social stressors, resources or lack thereof, gang activity, drug use, high numbers of incarcerated parents, whatever those might be. And all of these disparate pieces are linked, though. Principles, policy, and funding goes through the Office for Juvenile Justice and Delinquency Prevention, otherwise known as OJJDP, which is authorized through the Juvenile Justice and Delinquency Prevention Act at the federal level. So there is some federal guidance. Historically, the concept of a special court system for juveniles is just over 100 years old in the United States. It was originally, the first was established in Cook County, Illinois, and originally guided by the idea that society has an obligation to support and guide children to adulthood. and that they're worthy and capable of rehabilitation. For that reason, their crimes and the consequences for them should be considered differently than those of an adult. And the goal was not punishment, but reform and putting a child on the path to responsible, law-abiding adulthood. Unfortunately, the juvenile justice system has not always been able to deliver on these principles. In this extremely brief discussion, I'll only point out two that are most germane to our topics, but there was a period of time in the 80s and 90s that many of us would remember where there was a very tough on crime politics sort of guiding our nation around how things were issued. And juvenile justice was no different than the adult criminal justice system. There was the concept of a super predator, that there was a whole generation of juveniles who were growing up lawless and ethicless, frankly, and ready to be violent perpetrators. That never materialized, thankfully, but unfortunately it had ramifications on how laws and the application of those laws impacted youth. There was also a procedural shift in the courts that dramatically impacted its overall philosophy over time. In the 60s, attention started to be paid to whether or not juveniles should have access to the due process rights of the accused that were present in the adult criminal system. This focus, which did provide protections, and those were important, unfortunately also focused the energy and attention on the criminal attributes of these cases, and they gave judges less opportunity to consider flexible responses to the treatment needs of the youth that were brought before their bench. So, ironically, it became harder to treat youth differently from adults as they obtained more rights in the eyes of the court. Other institutions shifted from their primary responsibility to support youth as well, most notably education. Again, since this is a brief overview, I'm giving only the tips of these particular icebergs, so I'd encourage anyone unfamiliar with these concepts to learn more. Though I'd be surprised if anyone these days has not heard of the concept of the school-to-prison pipeline. In its briefest definition, this is the name we've given to the phenomena of schools that fail to serve cohorts of students and also essentially funnel those underserved students towards the judicial system. After the tragic events at Columbine, and in keeping with this theory of being tough on crime, many schools, districts, and states began to pass laws that criminalized many of the behaviors at school that formerly had been things that were just handled within the school day to day by school administration. These zero tolerance policies have led to increased and intensified exposure of youth to the law enforcement community, who is now thrust into the role of school discipline in an adversarial role, with limited options for how they responded. Even when the police are not involved directly, suspension and expulsion are the favored discipline actions under these policies, which only further sends the message that some students don't belong and are not supported by the school environment. Students with disabilities and students of color are disproportionately sanctioned with suspension and expulsion. And we know that each incidence of these sanctions increases the likelihood of dropping out and of incarceration. Many of these incidents result from the school's inadequate services for academic and behavioral support, as well as a lack of understanding of the impact of trauma on learning and behavior. So many states have started to pay attention to this phenomenon and have started to make statutory and regulatory changes. And there has been some very promising work done in pockets across the country. But for the most part, the change is slow in coming. Schools have had a long time of learning to deal with behaviors in the old way, and learning new ones is taking quite some time. It's a steep learning curve, and these institutions have some real competing priorities, which is a challenge. So the news is not all bad from the juvenile justice front either. There has been quite a bit of attention paid to reform and improving the services that are able to be offered and the systems within which they are granted. Some of this comes from outside the private, such as the MacArthur Foundation's Models for Change initiative. And that's really engendered with OJJDP as a partner some sort of from the ground up engagement from the juvenile justice community, which is very promising. It's centered around an advanced understanding of the original idea, right? That now what we know about brain science has shown us that the adolescent brain is still developing. Therefore, you can't treat it like an adult. And that any efforts at intervention and rehabilitation have to consider those differences in order to be humane or effective. So there's 4 areas: juvenile defense, adjudication of status offenses, mental health needs of juveniles, and the cross-system work with child welfare systems, since so many of the child welfare youth will enter into the juvenile justice system. And that's something we'll talk about a little bit more as we go on. You would think that with all this attention paid to the delivery of intervention that is developmentally appropriate for adolescents, that we would also be talking about how intellectual and developmental disability impacts a youth, whether through their entrance into the juvenile justice system or how it can be considered for effective intervention. But we haven't yet. We're not there, and that really needs to be our next area of focus. So those of us in the field can tell you that we've all worked with youth who were under-identified and underserved regarding disability. And our gut tells us that the numbers that we do have to be suppressed. Logically, we know that anywhere from 60 to 70% of the youth in the juvenile justice system are also child welfare youth, those same dual status youth I referenced earlier. We also know that many of these same dual status youth have a wide range of disabilities. Unfortunately, it also goes with the territory of requiring child welfare services. But since we don't aggregate any data nationally about the prevalence of youth with IDD in either the juvenile justice system or the child welfare system and their outcomes, we can't say much specifically about them. It leaves us disadvantaged ourselves in terms of how to address these issues. And there are lots of reasons for this dynamic, some which are more obvious than others. If you look at the chart I have here, I've done my best to represent, simply I will grant you, the correlation between the impact of having a disability and the level of advocacy a child receives regarding a disability. You'll see that in the upper right-hand quadrant, the intensity of need is high, but so is the advocacy. The way that that child is diagnosed, receives appropriate assessments and services, and just as importantly is viewed, is significantly different from those in the upper left-hand quadrant. Same level of need, but significantly less advocacy, and therefore perhaps not the same diagnosis, not the same level of assessment or services, and less ability to affect the lens through which they are used and viewed. Interestingly, the youth who fall into the moderate category of intellectual and developmental disability with low advocacy are significantly at risk. They're the ones who are often misdiagnosed or have no diagnosis. Excuse me. They have a significant enough disability to impact their adaptive behaviors and their self-regulation without the appropriate diagnosis, assessment, or intervention, and nobody to give someone a different view of their behaviors when they are perhaps before a court or dealing with a police officer. And the fact that they present with these challenging behaviors but not as obvious a need means that they're frequently put into categories where their behaviors are considered volitional and therefore require negative consequences rather than the additional support that is probably most needed. So, for example, we know the high prevalence of youth with developmental disability as a result of fetal alcohol spectrum disorder. And we know that many of those same youth will have families involved with the child welfare system. And we know that 60% of those diagnosed with FASD over the age of 12 have at some point been charged with a crime. And yet, as a practitioner, I can count on one hand the number of children I've worked with in the juvenile justice system who have had this identified clearly. But I certainly saw an awful lot of kids with oppositional defiance disorder diagnoses. Advocacy affects the lens through which a child's behavior is viewed and understood. And youth in the child welfare system and others approaching the juvenile justice system also have the overlay of trauma to the more organic issues, further complicating their cases and their ability to communicate with those who might affect their placement. So we know that the biggest population that we can identify clearly nationally that's moving towards the juvenile justice system are those in the child welfare system. We also know that those in the child welfare system do not have the strongest advocacy. I don't think there's any coincidence that that pocket is where a good chunk of our students who perhaps are not identified as intellectually or developmentally disabled, or who have and just haven't had the advocacy in order to get the proper services, are coming from that cohort and moving into the juvenile justice cohort. There are a number of challenges to this. People would say to me, well, why don't you just identify them in the child welfare system, which would make perfect sense. But it's not as easy as it might sound, and it is a place where we really need to focus some attention. First, there are discrepancies between policy under IDEA and practice in most states. There are child find requirements on the books that prioritize youth in the child welfare system, but I think anyone who has engaged with a local educational authority or tried to obtain a medical diagnosis realize that it can often take lengthy and complex advocacy and frequently family resources to obtain proper evaluation and services. So that is frequently lacking for foster youth. The transience of this population makes a lack of consistency or follow-through in the diagnosis or intervention. So if you identify that in one place and then a disrupted placement, which is unfortunately the norm, results in that student moving schools, moving medical facilities, perhaps changing caseworker, then we have more places for this particular ball to be dropped. And despite a few small pockets of best practices, there are some nationally where people are really tackling this issue. We have not brought these to scale, and we have not really addressed directly where practice doesn't meet policy, and our outcomes unfortunately show this. These things we do know, and you'll forgive me, I wish these stats were more about youth with intellectual and developmental disabilities. What they are about is youth from the child welfare system and where they will end up. We don't have those numbers because nobody's paying attention, nobody's counting, and we don't really have any way of even knowing whether the diagnoses that we might have on hand are an accurate reflection of the youth we're actually working with. So we do know that the rate of disability and special ed involvement is 0.5 times higher for youth in the child welfare system than the national average, and that number continues and rises as youth move into the juvenile justice system. That 30% of foster care youth entering the juvenile justice system do so through placement-related behavioral cases. And 25% of people leaving foster care will be incarcerated within a few years, 50% of the young people leaving will be unemployed. And in just one state study, California State Prison identified that 70% of its inmates were former foster youth, and I would posit to you that a large portion of that population is probably also struggling with disability. So what we don't know, and where I would love to see us focus some energy, is how many youth in the child welfare or juvenile justice system are diagnosed with an intellectual or developmental disability, how many youth perhaps should be and are not, and what might a universal screening protocol look like for high-risk populations. Perhaps to identify, as Karen pointed out, while a youth is in the foster care system prior to their entering juvenile justice, or while they are struggling with other familial challenges at home if child welfare has not actually become involved yet. And what might best practice interventions look like for those youth with IGD? It is so important that we know, because as Karen pointed out in Justin's case and in so many others, there are youth who are functioning in settings that are not providing what they need in order to move on, move out, and have a productive and safe transition back to the community.
All right, thank you, Lee. So our next presenter today is Gretchen Godfrey and Lily Garfinkel. Ms. Godfrey is the Assistant Director of the PACER Center, which stands for Parent Advocacy Coalition for Educational Rights. And their mission is to expand opportunities and enhance the quality of life for children and young adults with disabilities and their families based on the concept of parents helping parents. Ms. Godfrey is joined by Ms. Garfinkel, who works for the PACER Center as their Juvenile Justice Project Coordinator, advocating for children with and without disabilities who are bullied in the U.S. and other countries. So with that, I'd like to pass things off to them, and we'll hear from the PACER Center.
All right, thank you very much, Catherine, and good afternoon, everyone. As Catherine said, PACER Center is a parent advocacy organization. We work with parents of children from birth through young adulthood with all types of disabilities. And so we chose to focus our section of the paper and presentation on prevention strategies that parents can take to kind of move along that advocacy continuum that the previous speaker kind of mentioned. So I'm going to start just one second here. All right, I'm going to start with a few reasons to focus on prevention. As has been noted already, there is an overrepresentation of youth with disabilities, including intellectual and developmental disabilities in the juvenile justice system. We don't know the exact numbers, but we know that is there. There is a greater vulnerability of youth with intellectual disabilities, and also, as was mentioned, the prevalence of zero-tolerance policies and punitive-based discipline policies. It's really important to, as much as possible, prevent interaction with the justice system in the first place. And Lily's going to talk a little bit more about the vulnerability issue.
Thank you, Gretchen. If I had to pick out one issue from that list, is the vulnerability of kids. I'll give you one example that I came across a number of years ago, and there are many more. Child in school who had some significant developmental disabilities, good student, never caused a problem, but became anxious easily in a large crowd when there were issues that he didn't understand. They happened to be talking about Columbine because there was a focus on violence in the schools. He became very agitated, and he said, well, if it was me, I would take a gun and kill Mr. So-and-so, which immediately got him into the office of the school liaison officer. And nobody was there with him, but they asked him a lot of questions that he didn't understand. He was not a candidate at all to have taken a gun or harmed anyone. He was a totally gentle person. But they whisked him off to juvenile detention. They didn't call the parents. And there was no process in place for due process or his rights or having somebody who understood his disability available to him. And in the end, the parents were lawyers, so this was unfortunate in them picking this family at all because they were, of course, entirely furious and went down there and were able to get him released. But I always would think about the kids who didn't have a parent, like Justin, who didn't have an ally, who didn't have an IEP team looking after them, PCA or whatever they needed, to speak on their behalf. And you add to that the vulnerability of kids if they are in a system in terms of meeting the obligations of their sentencing, of understanding what they have to do in a correctional facility. As I said, there are kids who are in a facility for much longer because they can't meet the requirements of, because there are no interventions that meet their needs. So it's a huge, huge issue, and I think both schools and parents need to understand how to advocate for their child and how to collaborate with the schools and with the juvenile system, with police departments, to talk about their child's disability and what are the triggers that may cause behaviors that alarm people. So it's a complicated issue, but I really believe with the right kind of training and understanding of the kinds of initiatives that can be in an IEP or in a treatment plan, or in how to identify a kid who has an intellectual disability, we'll be much further ahead.
All right, and that is an excellent segue into our next slide. We're going to kind of talk about ways that parents can advocate and prevent involvement in the juvenile justice system at school, in the community, and online. So our first location, so to speak, is at school. So if there are recurring discipline issues for a child with a disability, we'd of course encourage the parents to request a functional behavioral assessment that will look more into the reasons the behavior is occurring, and then result in a behavior intervention plan so that all the school staff are on the same page with what types of positive behavior interventions can be put into place so that the student is kept moving forward. And then, and also, and besides just the behavior intervention plan, having a crisis plan for if, anxiety or something like that gets to the point where the student can't stay in the classroom or needs kind of a safe place to be, that there's a crisis plan in place so that the police do not have to be called. There can also be IEP provisions such as allowing the student to leave the classroom when they get anxious or there's an issue, and other de-escalation strategies such as the crisis plan. Another important thing to look at for school is signs of bullying. We do know that students with disabilities are bullied more often than their peers without disabilities, and a student with an intellectual or developmental disability, it's possible that because of their impulsivity, they might respond in a violent way or in another way that could lead them to involvement with the justice system. So it's important to be looking out for signs for that. And then even with all these prevention strategies, if the police do get involved at school for some reason, it's important that the IEP states that the parents must be called if the police are involved. That seems pretty straightforward, but we get many calls from parents who don't find out that their child was taken to the police station until they don't come home from the bus. So making it very clear that the parents must be called and that either the parent or an IEP team member must be present when the child is being questioned. Lily, do you have anything to add for the school setting?
I think so. Thank you, Gretchen. I also recommend to parents the part about there should be somebody, ideally, the attorneys that I consulted with when developing these points said, you have to have an attorney there. Well, the chances for an attorney getting to school meetings on these issues on a regular, easily, are not that great. So I suggest that there should be somebody from the IEP team that should be available in case that child has questions, whether they're questioned by the police or even the principal or whoever's in charge of discipline in the school, because they can make statements that are very incriminating. And if they're under stress and they're agitated and they may have some comorbid emotional disorders or, and I'm glad you mentioned, trauma, they may react in a certain way that would be would not be good for them, and they could be seen as someone who's got a violent tendencies or is aggressive. So I would suggest there should be somebody from the IEP team and understands how to de-escalate behavior, and that children should not be able to should always be cautioned to not sign anything, whether it's a confession. And we know a lot, and I'm sure everybody here knows a lot about different techniques of getting kids to confess. And all kids are vulnerable to saying the wrong thing if they're under stress, but kids with intellectual and developmental disabilities are even more so, and will sign things willy-nilly. If someone says, if you sign this, you can go home, or you can go back to class, or your mom will come. So we say don't sign anything without somebody that's an advocate or someone in the room. And we also tell kids if they are stopped by the police, we encourage parents to have a protocol for their children if they're stopped by the police, because that's an important piece. And one of the things would be never to put your hands in your pockets if you're talking to the police. A couple of parents mentioned that to me when I was working with them, because they might think that they have a gun or a knife or an object that would be dangerous. And I think none of us, we all know what's happening now, and I'm not blaming police, I'm not blaming anyone, but I'm saying terrible situations happen and people act impulsively and in fear. And typically these are not kids to fear.
All right, thanks, Lily. We've segued into our community setting slide here. And as Lily mentioned, parents can teach their child about what to do if they are stopped by the police or questioned by the police in the community. Simple things like being polite and respectful, not running away, sharing only their basic information such as their name and age, but not answering any further questions without a trusted adult present. Lily also mentioned, for example, about, teaching children not to put the hands in their pocket. One thing we encourage in terms of identifying a child or a student that's having a disability is using an ID bracelet rather than an ID card in case the child or youth were to reach in their wallet for the ID card and it was perceived as reaching for a weapon. So that's one way to make the police aware that the child has a disability from the outset. Another proactive thing that parents can do, especially if they're concerned, if they're really concerned that their child or youth is going to have an interaction with the police, is to actually visit the police precinct in their neighborhood, introduce them to some of the officers, and then explain, how the child's disability impacts their behavior, how it impacts their ability to respond to questions or directions, and really do that proactive approach. Students with disabilities are also more apt to be subject to peer influence, and so to teach the child how to recognize signs that maybe someone is taking advantage of them, and someone, they might do a behavior because they think it's going to earn them a friendship with someone or make someone like them when really they're being tricked into something that they don't want to do or shouldn't do. Another thing to mention with all these strategies is the need to do things such as role play and really repeat the instructions to the children and youth so that they are able to practice their interactions with the police or kind of learn how to apply what they've learned to multiple situations.
I think I'd like to add to that, Gretchen, that should be done more often, the same lessons more often, because all kids have trouble addressing these, how to respond from the specific into the general. It's how we teach children about sexuality and how to be careful about people and people who ask questions. You really want them to see it in all settings. And I think that's very, very important. What would you say to the police officer, or what would you do if this happened to you? And keep a script. I also really recommend, we also recommend that kids have a script of what to say and practice that script. And what happens if somebody is mean or scares you, what do you say in that case? It's about being prepared. And there was, in Maryland, there was a curriculum that I had access to a long time ago that separated what to look for in people with mental health issues versus people with intellectual disabilities. And I think knowing that difference is important, as is the fact that some of the kids have comorbid conditions, and I think Gretchen mentioned that. So their behaviors may be out of keeping with what the kind of attitude people have about kids with developmental disabilities being one kind of personality.
The final, or one of the final settings we're going to talk about is the internet, which has become a new area where children and youth with intellectual and developmental disabilities can inadvertently become involved with the justice system. So we encourage parents to, as much as possible, monitor their child's use of the internet and social media and chat forums so that they're aware of what types of sites they're visiting and what things they're seeing online. Like Lily mentioned previously, reinforcing what the rules are for internet use and what types of sites are safe and what aren't, And again, teaching, signs that the child and youth can look out for potentially being manipulated online, and practicing these skills repeatedly. So if you're asked for your personal information, you don't provide it. If you're asked for a credit card, you're not, providing any of that type of information. Teaching about what pornography is and knowing not to visit, what that means and not visiting those sites. So all those types of repeated instruction is really helpful.
And I'd like to reinforce that. I think it's really important. I've had a number of cases. They all kind of came in clumps of young adults. They were in group homes who had intellectual disabilities, who were getting porn on the internet from friends and sending it on. And one of them was captured in an FBI sting. And they really wanted to charge him with distributing pornography. He didn't even know child pornography, which carries a higher sentence. He didn't recognize it as pornography. He didn't recognize it as children because, like a lot of adults, they didn't look childlike. But it was so easy for that to happen, and it took a long time of convincing the attorneys that while that he really didn't understand what he was sending out, but the porn, like for a lot of kids without disabilities, is a very attractive site. We don't want to admit that or acknowledge that, but there are a lot of kids who know how to access porn sites, and for these kids, it brings a totally different set of problems. Not the least of which is imitating behaviors in very unsafe sites, imitating negative behaviors or problematic behaviors in the community will get them into a lot of trouble.
The last thing we're going to really talk about in more depth is that despite, these prevention strategies that we've talked about, there's, of course, always going to be instances where children and youth are involved in the juvenile justice system. So a few of the strategies that we like to stress with parents, again, reinforcing with their child not to answer any questions without a parent or IEP team member or other advocate present, not to sign anything. Again, as soon as a parent becomes involved and is with the student to let the police know what the child's disability is, it may be helpful to provide documentation such as the IEP or evaluation to help the police understand more about the child or youth, and also to really explain in practical terms how that disability is going to impact the child's behavior and ability to understand both the charges and to respond to any questions from the police or others.
I just want to add one thing. I encourage the child's physician, whoever is treating the child, in my experience, a lot of cases where kids got involved in more impulsive behavior was they weren't on their medication, or they were more aggressive because they weren't on medication that kind of decreases their aggression or their aggressive responses. So I always ask if they are using medication and were they using medication at the time this happened. And if so, use that in the case, any charges, and also explain that to police officers. We're not saying that behaviors happen because they weren't on medication, but there are some mitigating factors, and that the child isn't a danger, because you don't want that kid labeled as a danger to the community. So there are a lot of other possibilities.
So just in closing, obviously parents don't want to think about their child having an encounter with the police or correction system, but because of the greater vulnerability that children and youth with developmental and intellectual disabilities do have, it's important to think about and to have some of these proactive steps in place, the instruction on what to do if a police officer is involved in the various settings of the school and the community and online. So there are steps that parents can take to help prevent these encounters. Thank you very much.
Thank you.
Thanks, guys. And just as a reminder to those of you using your computers to watch, we have one more presenter today, and then we're going to do a Q&A session. So if you have questions for any of our wonderful presenters, please put them in the chat box or in the Q&A section. And if we don't get to everyone today, then we'll follow up by email. So our last but not least, our presenter, Catherine Perez. Catherine is a current PhD student who has published on various disability rights-related issues, including mental illness and employment discrimination. And she joins us today to present on special education in juvenile detention and youth detention centers. So with that, I will pass it over to Catherine.
Thank you. Let me just get my camera. So, as an introduction, I would also like to state a little bit about my program that I'm in for the PhD, and it's a PhD in disability studies. And in disability studies, we reimagine disability, moving away from the historical medical model of disability, which sort of problematizes how we look at disability as something internal to the person with the disability. And instead, we critique institutions and look outward in more of a social political model and see how we can reimagine these different institutions to accept and even celebrate people with disabilities. On a personal level, I'm also a person with a disability. I'm also a sibling of a person with intellectual disabilities, so any topic on intellectual disability is always near and dear to my heart. I did a 4-month clinic, legal clinic, in which I worked in some of the halls in California, the juvenile halls. And this is where I collected a lot of my stories, of which I'll go through a hypothetical, which is sort of amalgamation of some of the students that I was able to talk to about their special education experiences. So as an introduction, in 2010, there were more than 2,500 juvenile justice residential facilities in the United States. And as you can see, the breakdown on my slide, committed is about 42,000, detained is almost 20,000, and then there's discrepancy in the total, and that is because there are also some juveniles who are in diversion programs, which are these new innovative programs which are pushing away from sort of the prison model and more of like individual, parental, or family counseling. So when we're talking about the juvenile justice system, like one of the previous presenters said, it's really a combination of different systems. And in California, I noted that I'm from California, although right now I'm in Chicago doing my PhD. We unfortunately house the most juveniles in these centers at 9,810. So that seems to be a little disproportionate to California being only about 10–12% of the total population in the U.S. And then Texas and Florida are following behind in numbers of how many juveniles are in their systems. And as was also discussed, we don't really have exact numbers of children with disabilities, much less specifically children with intellectual and developmental disabilities, but we know that around 70% of students in juvenile correctional facilities may qualify for special education. In 2013, we had 16,157 receiving special education services, but that is not to account for those who, under the Child Find Service, we haven't identified and who may need services. So that's about a third of the population in 2013 was receiving special ed services. 55% of juveniles who are released from these centers will come back to the centers within 12 months. And it has been found that there's a high correlation between providing educational resources and reducing this recidivism back to the juvenile halls. And then lastly, I noted, just because I saw this statistic in my research and it was pretty jarring, that there are 2,570 people in actual prisons, not the juvenile system, who right now are doing life without the possibility of parole, and they entered that prison system and those sentences before their 18th birthday. And as you may know, the Supreme Court in 2012 in Miller v. Alabama sought to remedy this injustice, really, by striking down the sentencing schemes that mandate life without parole for juvenile offenders. I just found my thing. So moving on. So here's my hypothetical. It's also on the screen. You can read along, but I'll also read it out loud. Jose is a 15-year-old boy with intellectual disability. Jose's mom is a single mother who works full-time. It's October, and Jose has just started his freshman year in high school. His IEP stated that he would be in a general classroom, but he also has individualized goals for each subject. He also has a behavioral plan to address various behaviors, including inappropriately touching himself and others. Unfortunately, Jose recently entered a juvenile detention center pending his hearing with the judge. While at the hall, officers processed Jose without record of his IEP. The school had not transferred the documents in a timely manner. Jose told an officer that he had an IEP, although he said he didn't know what was on it. So the correctional officers decided to place Jose in their special day program. Every day at the special day classroom, several students at various levels receive the same worksheet to fill out. Once a student is done, he turns it into the teacher, who places them in a folder. And Jose says later on to us that he never saw the worksheet again, or any of those worksheets that he completed. One day, Jose had a behavioral episode for which he was placed by officers in solitary confinement behind a still door with no physical or social communication for a whole day. Jose was given, however, his worksheet for the day. After 2 weeks at this detention center, Jose was relocated to another facility. And it might be worth mentioning, because in my previous slide I distinguished those committed and those detained, that generally those who are detained are in a temporary, or hopefully temporarily, within the center, within the hall, and awaiting hearings or pending dispositions. They're awaiting a placement. So it's up to the court's discretion. And typically this should be a 72-hour or less, but the average stay in juvenile detention has been about 21 days. So the law, the Individuals with Disabilities Education Act of 1990 guarantees that every child with a disability between the ages of 3 and 21 in the juvenile correctional system is entitled to a free and appropriate public education in the least restrictive environment. So under FAPE, juvenile detention and youth detention centers must provide special education and related services without charge to its students and its families, and tailor each student's education according to their individual needs. And under LRE, or least restrictive environment, which we also call mainstreaming policy, juvenile detention and youth detention centers must provide students with the right educational placement from a continuum of options, which may include special classes and also integration into regular classrooms. And the law requires that students integrate into typical classrooms with non-disabled peers to the maximum extent appropriate. And was also previously discussed, schools and juvenile detention and youth detention centers are also legally required under the child find mandate of the IDEA to identify, locate, and evaluate all children with disabilities who may be eligible for special education and related services. The IDEA also calls for a practical method developed and implemented to determine which children with disabilities are currently receiving special education and related services. And the IDEA and its regulations also provide parental rights, which are also called procedural safeguards, which include the parent's right to be informed, to consent, to request an evaluation, and participate in meetings. These safeguards include providing a surrogate if the parent is unknown or the child is a ward of a state. And the IDEA requires that assessments of children with disabilities who transfer from one public agency to another in the same school year are coordinated with those children's prior and subsequent schools if necessary, and as expeditiously as possible. And then lastly, although this is not a comprehensive list of all the IDEA, that when a youth in the system turns 16, or any youth in the school systems, that any school, but including juvenile hall, they must update the student's IEP with proper transition goals. So all of that is in the most perfect scenario that this would happen. And unfortunately, it's not always happening. So as an example, let's go back to Jose, and let's do what we call in law school issue spotting, or as attorneys, I guess, in real practice call issue spotting. It's also the problem. So what brought Jose to the hall? So we want to look at, again, from a disability studies perspective, we want to look at what institutional failures, what happened in the schools, what happened, for example, interaction with police, which I thought the previous presentation was really excellent. It gave some practical advice for parents in interacting with police. And in a larger disability studies policy view, we also like to look at how can we change the institution of police interacting with people with disabilities, and especially people with intellectual disability. And we know nothing really occurs in isolation. A lot of people have comorbid or intersections with race, with mental disability, you know, with different class statuses, et cetera. So from a disability studies perspective, we want to look at not only teaching these children with intellectual disability how they should respond when interacting with police, but we also want to look at how the police departments are interacting with our kids, and what we can do at policy and institutional levels to change that, to address why, for example, Jose came to the hall in the first place. So we also want to look at, again, looking at the institutions, was his IEP and his 504 plan even working? I mean, he just started as a freshman, and in October, only supposedly a couple months into school, he already is going through the juvenile hall system. So really, did we fail him at that level? Was his IEP working? You know, did we need to call another meeting with the team and go from there? And it's also tricky because the hypo did talk about inappropriate touching. Of course, you know, that's only one of many behaviors that people with various disabilities, including intellectual disability, may have. And it is really difficult, you know, again, looking from a disability studies perspective and taking the social and political model into account. It's a little bit more difficult looking at people with intellectual and developmental disabilities. So let me put it this way. The ADA covers, you know, various people with disabilities, all disabilities. But we have had, or in my opinion, and many people's opinions, we've had more success sort of looking at and changing physical structures and physical barriers for people with physical disabilities. So whether that means, you know, putting in ramps, changing spaces to accommodate people with different physical capabilities. But for people with intellectual and developmental disabilities, it's a little more challenging to reimagine what our society should look like to accommodate people with intellectual and developmental disabilities, especially children. We need to think more creatively about contesting norms that we have about behavior, norms that we have about speech, norms that we have about how we sit quietly in schools, for example. So we also want to look, when we're doing his IEP and his 504 plan, we really want to try to challenge the institutional setting and question why certain behaviors are really not acceptable, and how can we sort of push the bounds to reimagine a world in which persons with intellectual and developmental disability are celebrated. So the movement of records, in this hypothetical, I heard it from dozens of students with whom I spoke, and also the correctional officers, that, you know, if students are only there 72 hours or 21 days, and it takes a month for the school to transfer the records to the hall, unfortunately, and that goes to the next point, the communication is really left up between Jose or any student with IDD and the correctional staff when they're coming into the system. And some of our students with IDD have a lot of communication issues, so the correctional staff might be relying completely on the student to tell them, do you have an IEP? Are you in special education? What's on your IEP? And many of our students may not know exactly what's on their IEP or their behavioral plans. And even so, even if they did get those records, right, we still have the issue of, do they have the appropriate resources? Do they have the LRE, the continuum of placements available at the hall, right? So in this hypothetical, and it was very prevalent for the students that I spoke to, and specifically in one hall in California, there really was only a regular classroom and then sort of segregated special day classroom. And anyone who identified as having a disability, definitely anyone with IDD, was just placed into this segregated special education classroom, right? And so it's not really acknowledging LRE or the variety of IEP, and really it speaks to the lack of resources that a lot of these halls have, or resources that they're not appropriating to education. And so that, I also touched on LRE and individualized education. And then lastly, I wanted to make a note about credits, because a lot of the students themselves did express, I think one of their biggest worries about their interface with the school system and the juvenile halls was, I've been here for, so many months, and I'm not really doing, I'm doing biology and I should be doing chemistry, right? Or I'm doing regular math and I should be doing algebra. So, I've already done this, so I'm not really getting credits, and the amount of time that I'm moving from hall to hall, I'm not getting credits toward my graduation. Or if they move with only a week or 2 weeks, do they get partial credits? Like, how does the system work to move credits around so these children are on a path toward graduating? So some of the principles and solutions that I include in my white paper include individual advocacy, policy initiatives, and impact litigation. But first, I really wanted to say that youth with IDD imprisoned by the juvenile justice system, they have a moral and a legal right to education. So the Department of Justice and also Department of Education, which I'll get into a little bit later, released last year, as many of you probably know, sort of a series of best practices. And in reading that today, I read that it said $1 of correctional education investment can cut reincarceration costs between $4 and $5 the first 3 years post-release. And of course, this is a huge policy point, right? In the disability community, we always want to talk about costs because everything always comes down to cost. And so one of the solutions, obviously, that I'm and advocates are pushing for is to provide the necessary funding. And that also goes toward recruiting and retaining qualified educational staff, creating relevant curriculum, and we should look at the IDEA also as a baseline of what we should be providing to our students. We should seek to go above and beyond that. And in the white paper, I did speak about the Angela Mayo Center. I don't have that in front of me, but it's in the white paper. They really are responding and going above and beyond, providing different arts classes and various different classes within their program for kids with IDD and other disabilities. And of course, we need to be conscientious of prompt movement of educational records between the institutes. And that means just institutes working together, right? So the school system working with the halls, and especially now that we have, such great use of electronic formats, just pushing those records a lot more swiftly so that students can receive the services that they need. And then also, although in detention centers, students typically should be there about 72 hours, that doesn't mean that, they go back home and everything's great, or they go back, to their schools. For a lot of these students, this is going to mean transfer between different institutions and sort of this school-to-prison pipeline cycle of going between various halls and other institutions. And then lastly, one solution that states and juvenile halls should know is that federal Pell Grants also pertain to students in the juvenile justice system. Although federal Pell Grants don't, by law, do not follow people as they go into prison settings, the Department of Justice has clarified that juvenile hall is not seen as an equivalent of a prison setting, that it's more of a rehabilitative. So juvenile halls definitely can make use of federal Pell Grants in getting some funding. So this last slide, I won't read that big quote. I provided you the link. I think it's in blue. It's on blue on my screen that you can click on. This quote comes from a letter dated December 8th, 2014, again from the Department of Ed and the Department of Justice. And it was addressed to the chief state school officers and the state attorney generals. And it was written by, well, it was signed by at least, Arnie Duncan from the Secretary of Education, and of course, Eric Holder, Jr., the Attorney General of the United States. And they offer, along with this letter, this guidance package of, like I said, best practices that they have developed. So I encourage you to, click on that link and look around. And they give sort of guiding principles for providing higher education in juvenile justice systems. They have a Dear Colleague letter on the IDEA for students with disabilities in correctional facilities, a Dear Colleague letter on civil rights of students in juvenile justice facilities, and then lastly, a Dear Colleague letter on access to Pell Grants, which I spoke about just recently. And in closing, I would just like to say thank you to Leanne and Catherine for allowing me to be on this panel and participate in the White Paper Series. This has been an excellent webinar. Thank you.
All right, I just would like to thank again all of our wonderful presenters today. And you heard all of them referenced, and Leanne told you about our white paper. So that will be available on our website. And there were a couple of authors, contributing authors to the white paper that were not able to make it onto the webinar today. So there's even more great information about justice-involved youth with IDD. We'll have more on that history and overview of research, more on Justin's story, some prevention strategies, P&A recommendations, school-to-prison pipeline, the special education in juvenile justice, and model program for at-risk youth, all included in that paper. So we hope that you all go and download. And with that, I also wanted to thank particularly the folks from Pacer Center for your brief foray into online safety. That will be our October webinar. So on October 29th, we'll be sending out an advertisement here soon. You can register with us. We've got 3 panelists that are going to come on and talk about sex offending risky behavior for people with autism in particular. So we're looking forward to that as well. And with that, I am going to go ahead and start asking some questions to our panelists. And just as a reminder to our panelists, make sure you're unmuted when you start talking, because as you saw at the beginning of this webinar, I forget to. So there's your reminder. And we will start with a quick question for Karen Grau. When will the documentary be released and in what venues? And then also, once it is released, do you have recommendations or plan in place for how agencies and communities can use your documentary to engage around these issues?
Thanks, Catherine. Actually, we plan to release the documentary in November, and we will have air dates and ways for people to get DVDs or streaming downloads of the film on our website, which is calamariproductions.com. And I'm sure the ARC will also be keeping folks updated as well, because we're happy to report that Leanne is actually in the film. So we were happy to be able to include her and the ARC in the documentary. We don't have the exact date in November yet, but I would just recommend that folks stay tuned to calamariproductions.com for updates on the film. And there is also contact information on our website for people who would like to contact us about hosting any screenings of the film in their communities and their jurisdictions. We do that a lot when we release our films. We're happy to come to various states and organizations to screen the film and open the film up for comments and questions. So stay tuned to our website, and that's where everyone can get updated information about the release of the film.
Right. Also, just as a side note, in the post-webinar survey, there's an option to receive NCCJD updates, and I'm sure we will be sending out an update as well, so when the film is available. So sign up for those updates, and you'll know for sure.
Thanks, Catherine.
Sure. Our next question is for our presenters from the PACER Center. Can these preventive provisions that you were talking about be included in a 504 plan if an IEP is not present?
Yes, absolutely. And I really recommend that. There should be something in writing. Now, schools may not always be eager for the involvement of a parent or another professional. Because of the vulnerability of these kids, I think there's a good case that has to be made to the school that it's in. So I would include
on that last comment. Can you repeat that last bit?
I think it's also in the school's best interest as well to have that kind of documentation about having the presence of either somebody who's an advocate or the parent who understands the disability, something that's selected and accepted by the school, you know, agreed to by the school. I shouldn't say accepted, but agreed to in the documentation. And, you know, sometimes it'll take time, and especially if they don't understand the disability and feel that the behavior is volitional. But, you know, you can quote the Rehabilitation Act, and, you know, that still is effective. It's not just the IEP.
Great, thank you. And this next question, I think any of the panelists that want to weigh in, you guys should feel free to unmute yourselves and weigh in. What can advocates do to prevent children from the child welfare system from entering into the juvenile justice system? So specifically, what can advocates do?
Hi, this is Lee. I would say that one of the key things that advocates can do for youth in the child welfare system is exactly their role, to advocate. And what we find is this is exactly the difference between kids in the child welfare system and kids who are not, is the presence of that strong, informed advocacy, which knows how to represent that youth in a way that can be understood by some of the other agencies that they're going to interact with. One of the things that they can do most importantly, though, I think, is work on identifying what those other agencies are and be active in their communities in interagency collaboration. My own organization, the Robert F. Kennedy Children's Action Corps, is active with one of our programs, the RFK National Resource Center on Juvenile Justice, and that its sole purpose is to work with jurisdictions to improve interagency functions and communications in the hopes of creating better outcomes for child welfare kids and hoping to not move them into the juvenile justice system. And information sharing and interagency collaboration is possible, but it takes work and it takes intention. And those are some of the things that seem to get in the way, despite policy that supports these very same youth. You know, I think the cases that we've heard today and the ones that most of us in the system have experienced ourselves are all impacted directly by the level of advocacy that those youth can receive. So really,
I think that's very true. I think it's very true. I also think that there has to be a lot more training about young people and older people with developmental disabilities and the comorbidity with mental health identification and how you address those issues through the welfare system, you know, training for judges, training for people who work in the system. guardians ad litem, you know.
Yeah, this is Gretchen from PACER. I would just echo that and say all of the strategies that we gave for parents could also apply to other advocates, whether it's surrogate educational advocates or advocates through the child welfare system, you know, such as, you know, working with the student on practicing those techniques for interacting with the police or looking at the IEP. Other advocates besides the parent could take on that role as well.
And Gretchen mentioned another professional that we don't always turn to is that of the parent, which I think is
Did anybody else have anything to add on that particular question?
The only thing that I would also add is that a lot of our advocacy hinges on the idea that a youth has already been identified as having a disability. So since advocacy is required sometimes to get that, I would also say that any youth that's in the child welfare system should be looked at closely for whatever supports are necessary. And that may be the identification of an existing disability. So close communication with the school, with the institutions that youth is interacting with, to identify any places where that child might need support might be the thing that actually leads us towards the identification of the disability and then increase advocacy on their behalf. So I would just encourage us to not focus our attentions on those who have already been diagnosed, because we know that there's a gap there as well.
And this is Karen, Catherine. The last thing that I would like to add is I have filmed inside child welfare and juvenile delinquency courtrooms for 17 years, and I can tell you without a doubt the children that have the best outcomes are the children who have the most support. And by supports, I mean everyone from family members to friends to teachers to counselors to anyone that intersects with that child that has some sort of background with that child that can be there to support a child in the courtroom and outside of the courtroom makes a big difference. I know many judges often tell me that a lot of their decisions are based on the support systems that they see when these children come into the courts and come into the system. So I always like to tell families, be loud and be persistent and make sure that you have as big of a cheering section, if you will, as possible, because in the eyes of the judges who oftentimes dictate the course of the future of these kids, that makes a huge difference. Once they come into the system.
Absolutely, thank you. Those are some great answers. The next question is having a competency evaluation completed a direction that will assist a client in their defense? Does anybody know anything about competency evaluation? All right, we'll follow up on email on that one.
This is Karen again. The only thing I can say, time and time again, I see in court that the judges in their rulings say, I'm going to require that a competency exam, determine where this child is at this particular time. I'm by no means any expert in competency evaluations. But I do, 9 times out of 10, see them ordered in juvenile court for children who come through the courts. I will say, though, I have filmed several kids who have been declared incompetent, and that doesn't preclude them from being sentenced to the Department of Correction. I would have to say in Justin's case in particular, one of the things people comment most on that is how in the world was he ever declared competent in his court hearing in order to be sentenced to prison? And I think that's an excellent question. A competency evaluation was not required for him during his court hearing, which I think is an egregious use of the judiciary, if you will. And I think that looking at a case like Justin's, when people see the documentary, that's one of the biggest questions that will probably arise is the issue of competency and how could he have ever been declared competent to go through the system and end up in prison in the first place.
I have to agree with that, that I've seen more than my share of cases of kids who are determined to be competent for the purposes of the court. And that's a very different standard than competence. And so I would agree that, you know, you can ask for that, but they really, the standards are not appropriate for this group. You know, there are kids that I would have the same question as you. How do they ever get determined to be competent?
Right.
All right, next one. In the absence of a current legal threat, for example, charges, should an adolescent with ID who exhibits uninvited sexual behavior have an attorney? If so, how does one go about finding such an advocate?
It's Karen again. Actually, Justin's case involves a sexual, inappropriate sexual behavior. That was what landed him in the juvenile court to begin with. And because of his disabilities, he really had no idea at the time when he displayed inappropriate sexual behavior. He did so in order to get attention from the adults that he didn't feel he was getting enough attention from. And he thought by inappropriately behaving in that way that they would then pay attention to him. That led him to the courts, which led him to juvenile prison. And I should point out that Justin himself was a victim of sexual abuse when he was a child. And as many of us on this webinar know, that is not at all uncommon because children with IDD are more predisposed to be sexually abused at some point in their life than children without. So in this particular case, and Catherine, you probably will need to repeat the question again. I think they were asking how you find someone, a lawyer, is that correct?
Yes, and asking if you're seeing risk behavior, if there is perhaps a reason to have a lawyer on call or on retainer, or what kind of strategies you would use if you think there's risk.
I personally cannot emphasize this enough after so many years inside these courts. I have yet to see a child without an attorney present have a good outcome compared to the children who do. I know it's a cost factor, but even if it's a matter of having a public defender assigned, I absolutely, positively recommend that any parents who are going through this process, and if it does include some sort of sexual misconduct, absolutely find a lawyer or a public defender or someone who can help navigate the legal process with this as well. You cannot go wrong.
And Karen, this is Leanne, and I would add to that that's the kind of thing probably the PACER Center has been doing for a long time, and that NCCJD is doing as well, is when we find out cases like these, is to assist that attorney in any way we can to help them understand the specific issues around youth or adults with intellectual developmental disabilities. So there are some services and supports out there that families can reach out to, such as NCCJD and the folks at PACER Center, to really get some support for that attorney or within the legal system.
And I just wanted to agree with the comments that have been shared right now. I'm an attorney, and whenever I've shown up to an IEP meeting at a school, the parents always tell me afterwards that, you know, they were taken a little more seriously, that things started getting done all of a sudden. So for whatever reason that is, unfortunately, it's probably better for parents to have advocates driving them along. And just in going with my comments about disability studies models, I think it's really important in this situation with uninvited sexual behavior that we conceptualize it, as Karen said, as a response to different things, external stimuli, such as you know, wanting attention. So meaning, are they not getting appropriate attention? And then also looking at what are some of the precursors, such as sexual assault that has happened before.
Thank you. All right, and next question. are there established programs that divert youth with ID from detention centers and jail? And if there are, I know we have a couple listed in the white paper, so I would encourage you all to look at the white paper, but do you guys have any you would recommend, panelists?
I would not say that, I think what's more prevalent is that there are programs designed to divert youth in general, and if those programs can be inclusive in their thinking around all of the ways that they can advocate for the youth that are referred to them, to incorporate thinking around how to best support youth with intellectual and developmental disabilities, that might be one of the best ways to approach this. Since, you know, again, the question of identification is sometimes an issue. There could be kids who really could access some of that, but who wouldn't be considered eligible because they don't have the right diagnosis. So there are the Detention and Diversion Advocacy Project, which is something that RFK does, so I know about that one firsthand. There are other models around the country that work to divert youth from detention, and I think if their thinking could be expanded to include youth with intellectual and developmental disabilities, we'd get more bang for our buck, for lack of a better way to describe it, than otherwise. Although specific advocacy, I would hope that they would have access to those who have a knowledge base in specific advocacy groups for the population with IDD.
Thank you. Anybody else on that one?
I think that this goes within the training of diversion programs too. You know, when we're talking, we always want kids to be diverted wherever possible, and to work with diversion programs in the community as an advocacy group, you know, or with ARC or any other groups you think of who understand this population, to teach them about how to interact more effectively with kids with developmental disabilities.
Great, thank you. Here's one. Do states have legislation in place to support schools in helping to identify students that have increased behaviors so that the schools then receive the support needed as an early intervention? For example, authority given to the school to provide assessment. So what kind of state legislation do you guys know about?
So this is Gretchenette Pacer. I mean, of course, the Individuals with Disabilities Education Act, which is the federal special education law, has requirements for child find, which has been mentioned multiple times in terms of identification, but also promoting the use of positive behavioral interventions and supports for behavior plans. So it's kind of there, but as people have mentioned, there are, of course, children who slip through the cracks if they don't have maybe the advocacy that's needed to get those services and evaluations.
I think it's also helpful to know what questions to ask. You know, we provide a lot of information to parents and to professionals, but I think I'm always wanting to do more about what are the questions you should ask the court or the attorney, because public defenders, as much as I really rely on them, they don't know a lot about disability. So it's about knowing what questions to ask in court and how to meet the needs of your client or the person you're working with.
Very true. And we at NCCJD have had similar experiences where public defenders may mean very well and do the job to the best of their ability, but if they can get support from an advocate or a disability agency to kind of help the court understand the disability angle, it can be a game changer. So I'm sure that applies, and the Pacer Center or NCCJD would be happy to help out if you guys have specific cases out there.
And Catherine, I want to add to that too, this is Leanne at NCCJD, and that we're attempting to do this really sort of big project, and that we're trying to get all of the different state legislation that affects people with IED into our database. So if you do know of programs out there that we can put into that, please let us know. one of the things that we've recognized is that there's really not one central location to find this kind of information, whether you're looking for an expert witness on a case or you're looking for, you know, what legislation is going on in Florida, for example. And so we're hoping to bring all of that under one roof within the center. So I'm glad that one of the participants raised that question. And anyone on this webinar who has information going on in your state, there's a way to get on our website to add that information, or you can email it to us directly as well.
And Catherine, I could add that in Massachusetts, we do have something called the Ed Law Project, which trains public defenders in how to best advocate for the youth that they might be representing from an educational standpoint and around disability rights.
Great, thank you. All right, here is another question. We are a small agency and can only start small in educating criminal justice professionals about youth with IDD. Where do you suggest we start, and do you know of any resources?
I would start as if I was working in a new agency. I would start to look at who your clients are. I mean, I don't know how much information you have about your clients. I would try and find out who those clients are, what percentage are clients who have parents or children with specific disabilities, and start thinking of the kinds of agencies that could collaborate with sharing information and empowering parents. That would be a start. You have to know who you're working with.
And I'll add to that, this is Leanne, that through the National Center on Criminal Justice and Disability, we are, as I mentioned earlier, developing curriculum to outreach to different law enforcement, different criminal justice professionals that are in our communities. And so, similar to what Lily said, really finding those and networking with those in your community that have similar interests around this issue. And we call those disability response teams, and we've been creating those and building those up throughout the country through our pilots of the training to try to, you know, not just put training out there, but really create teams of people who can sustain this type of education over a long period of time. So that's one thing that we're really interested in helping chapters do and other nonprofits do, is really create these really strong knit communities around this particular population. And we'd be happy to talk more about anyone on this webinar who's interested in doing that.
Great, thank you.
Catherine Enriquez. I think I just sent, if you can go to the Q&A section of this webinar, a link. I'm not sure where the organization who asked the question is from, but this is Disability Rights California, and their California's Protection and Advocacy System, and every state has a P&A system, Protection and Advocacy System. And here's just an example of how Disability Rights California, or DRC, has put together a really great manuscript on law enforcement training and mental health crisis intervention. And although it's California specific too, I'm sure it can apply and help others.
So I also put that link both in the chat box and then just typed it on the screen up there, so if anyone's interested in following up on that. She's right, the P&As are a great resource. And I believe we had a P&A contribution to this paper, so.
Yes, we did.
Yes, so they couldn't join us to present, but are actively involved. So I just want to take a few minutes. We've got about 10 minutes before our 3:30 mark. Do any of our panelists have closing remarks for the group? All right, well, thank you guys for being on the webinar today. I'd like to ask everyone to be sure to register for our next webinar on sex offenders with autism spectrum disorder. We're going to talk about internet safety, some kinds of warning signs, and then what to do once an offense has been committed and somebody is involved with the criminal justice system. We're really excited to follow up some on that particular issue. We'd like for you to sign up to receive email alerts and use our information referral service. And refer others to the center, share your resources. You'll have the opportunity to check a box on the post-webinar survey to receive our email updates, so we hope you'll do that. And just as a final reminder, you can download the paper, Justice Involved Youth with IDD, at thearc.org/NCCJD. And if you need to contact us, you have a question that didn't get answered today, or you'd like some more follow-up from either NCCJD or one of our esteemed panelists, you can contact us at nccjdinfo@thearc.org. So thank you for joining us, and we look forward to hearing what you all are doing out there in the world of juvenile justice.
And I just want to end by saying thank you again to all of our panelists. You put in a lot of work into this white paper, a lot of work into being on the webinar today, and just in your daily lives, all that you do to improve the lives of youth with intellectual and developmental disabilities. I personally want to say thank you, and we look forward to continuing this journey together with NCCJD, the panelists who are on the webinar today, and the rest of you out there joining our webinars. So thank you, and we will see you next time.
Thank you, Anne. Thank you, Catherine.
Thanks, Catherine. Thank you.
Thank you.